Okay, so let's get started. I think we're just going to go 1, 2, 3 here. I'm Greg Grossman from Sequor Law, based in Miami. Our little name is in the top right corner of the sponsorship thing, which I don't know if we had to pay extra to get to the top. I'm going to give you folks some new and breaking news from the States. You want to do that? Okay. Polly, why don't you introduce yourself before I go?
Yeah, so hi, I'm Polly Sprenger, and I think I've seen some of you from before, about 5 minutes ago when I was speaking in the other room. And I practice here in London. I'm a barrister in the UK, specializing mostly in civil fraud and asset tracing and private prosecutions work. That's just my hobby, that thing I was talking about over there. And next to me is a colleague from Liechtenstein.
My name is Alexander Amann. I'm an attorney based in Liechtenstein. We have an office in Switzerland as well. I'm licensed in Austria too, and we very much specialize in securities litigation, consumer litigation, and as far as Liechtenstein is concerned, of course, in asset protection and asset recovery cases.
So this is, to make sure you're all in the right room, this is high value cross-border recovery tips from the experts, part 1. That's like history of the world, part 1. Part 2, I think, follows us. New and breaking news. I'm the only Yank of the 6 panelists on this topic. So I'm going to give you some new and breaking news. Many of you are familiar faces. I want to talk about some new cases that have come out in the States regarding our statute, affectionately known as 1782. For those of you who don't know what it is essentially the doorway by which litigants, governments included though, where litigants can go to the United States and ask witnesses who are based in the United States, those who are resident or found in the United States, and demand from those witnesses information, testimony, production of documents, production of things. It's a very broad statute, but now, based upon some current case law, things are starting to get a little bit more tricky. I want to first talk about a case that came out a whopping 18 days ago. So you got to be on your toes in this conference. 18 days ago, thank you. The 11th Circuit Court of Appeals, which is the court that governs Florida, Georgia, and Alabama. It's a Circuit Court of Appeals. It just has a Westlaw site. It's just come out on the 24th of October. This is a fascinating case. So again, I told you 1782 is a petition by a foreign litigant or foreign government in the United States asking for the judge in the United States to order a witness to appear and give testimony, provide documents, or give information. This case involved a Russian businessman with companies in Russia. He was sued by the successor to his lender, placed into a bankruptcy in Russia. The trustees of the bankruptcy in Russia have zero funds. They have no money. They can't afford to do anything. The lender obtained a judgment back in Russia. That lender files an application under 1782. So this is very different than the last panel. We're talking about the powers of a trustee. This is a creditor and judgment creditor who has gone to the United States and asked for deposition and testimony and documents from the individual Russian businessman and companies that the man owned, was affiliated with, or held officer positions in. So these are not the companies that are in bankruptcy in Russia. These are other companies formed allegedly after the man left Russia and moved to the United States, where he became a resident. The interesting thing about it is you're talking about no insolvency proceeding created in the United States. So one of the arguments was, well, how dare this creditor come to the United States and file an application to get information? When there's a trustee, that's the trustee's job. It shouldn't be this creditor's job. And that was rejected on all the different levels of court. Basically because 1782 says the person who can be the applicant merely needs to be an interested person. The information they were asking for, they said, was for use in a foreign proceeding. And that foreign proceeding, they said, well, we're going to object to the man's discharge in bankruptcy in Russia. we're going to trace the assets to the United States to show that he didn't disclose the assets in the Russian bankruptcy, and that he transferred the lent money. Remember, this was a lender who sued. They're going to try and do a proprietary theory of that their money ended up in the assets in Florida. And they also said, well, they're also contemplating perhaps filing a civil fraud debt recovery action. So the one defense was, you're the wrong person, you shouldn't be applying. The second defense that was raised by the Russian and his businesses in the United States was that this is all a ruse because this is part of a long-standing saga by this lender to destroy the man's business under the famous Ritter-Stevo concept that the Russian, the powerful Russian folks were taking the man's business. All of that got rejected all the way up to the Court of Appeals. So as of 18 days ago, the law in at least part of the United States says a mere creditor in a bankruptcy has standing as an interested person to come to the United States and look for the assets of the bankrupt. So think about that. So if you're a trustee and you have no funds, but you've got a fancy creditor who's owed a lot of money and a big wallet and willing to take the fight, they might be able to bring the fight themselves. So that's big news for us. Let's see. The next thing that happened in the 1782 world happened 25 days ago. Now this one is perhaps putting a little bit of a lid on my exuberant belief in 1782, which we have filed. I can't tell you how many we have filed over the years, many dozens. The Second Circuit Court of Appeals on October the 7th has had a situation in which a group of Mexicans filed an application in New York asking for documents and testimony from a local bank that was owned by a Spanish bank. Now, the Spanish bank didn't do business directly in New York, except for its dealings with its subsidiary and its affiliates. All of this had to do with the sale of a business overseas. I think it was actually here in the UK. I'm not positive, though. So the two banks that were involved, there was an application made by these Mexican investors to Banco Santander, which is a Spanish bank, but in the United States. So they served the office of Banco Santander sitting in the United States. They also served it on an affiliate that was, in fact, a New York-based subsidiary of Banco Santander. And the Second Circuit, ultimately, going all the way up the chain, held two things of import. One, that the fact that documents are held outside of the United States is not important for 1782 purposes. So for instance, if I was the witness to your piece of litigation here in the UK, the fact that I decided to put all of my documents in Stéphane Bonifaci's office in Paris, but I have control over it, if you subpoena me in the United States, regular American law would say I have control over those documents and therefore I have to produce them. 1782 is exactly the same. So there's no special problem about the documents or the information not being in the United States. It's that the person is in the United States, that I am a resident and I can be found. So that part was interesting. That's the second time. We have two Circuit Court of Appeals who have said that 1782 applies extraterritorially. So the first one was Sergiva in the 11th Circuit, which again is my world, and now the Second Circuit in New York, covering New York and Connecticut, etc. So that's a big news as well, because there was some notion that said, well, an American judge shouldn't be able to order a witness to bring documents from overseas, from outside the United States, or for wherever they were, and produce them in the district, say in New York or in Florida. And that's now, we have two circuits. I think that's probably going to end up being the law. No split yet, so nobody's gone the other way. The other thing that's more distressing for an asset recovery lawyer is the second holding in the case. The second holding in the case was with respect to Banco Santander itself. Banco Santander SA is not an American entity. It's a Spanish bank. It does not have its principal place of business in New York. The Second Circuit took the US Supreme Court case law on personal jurisdiction, which if you think about it, personal jurisdiction is generally in an A versus B lawsuit, where you have to show, if you're A as the plaintiff, you have to show that B is subject to this personal jurisdiction of the court to get any relief against B. But we're not talking about A versus B. A versus B is somewhere else. A versus B is London or in Liechtenstein or in Switzerland. The person I'm trying to get the information from is C, a non-party, a witness, just somebody who has information that will be useful to my lawsuit out of the country, out of the United States, A versus B in Switzerland. The Second Circuit took the Supreme Court case law on personal jurisdiction and applied it. So as it called it, it had to translate that notion into the non-party witness world. So basically, it said, if the witness has its principal place of business in the United States, then they have general jurisdiction, and you can file your 1782 where they have their principal place of business, and you can get anything you want from them, because they're subject to, quote, general jurisdiction. Well, that's okay, right? If you're subpoenaing an American bank, you find their headquarters is in New York, or their headquarters is in Charlotte, or their headquarters is in Miami, whatever it is, you go there, you file your 1782, you get your documents. But what about a corporation like Banco Santander? Hundreds of millions of dollars of transactions are being done sort of under their umbrella in the United States. In the Second Circuit, they decided to apply specific jurisdiction. Specific jurisdiction is, if you think about it, the analogy is, I'm here in London, if I hit somebody with, if I go into a bar and I've had too much to drink and I get into a bar fight, I have specific jurisdiction. I don't live here, but the tort I committed is here. So they have specific jurisdiction over me for having committed the tort here. Similar in the United States. So if you came to my bar and you got into a fight and I sued you, then I would have specific jurisdiction even though you don't live there. Well, applying that in an entity concept, particularly in a bank, is an awfully strange thing. This bank has a place of business, but it doesn't have its principal place of business. So the court then went to 2 layers of specific jurisdiction and basically completely skunked the applicant. They got nothing, 0, from Banco Santander in the 1782 application. First, they held that Banco Santander's connections to New York were not so pervasive. So they had 2 different notions here. One is, does the company have pervasive but not a principal place of business, or do they have just tangential, sort of incidental? If they have pervasive, you have to show that the documents that you're asking for are connected, that but for the relationship to the forum, but for the relationship of Banco Santander to New York, those documents would not exist. Worse would be if it was more incidental. Banco Santander's connection to New York was more incidental. In that sense, you'd have to prove that the documents you're seeking were proximately caused by Banco Santander's relationship to New York. So
does this mean that if you were seeking a Section 1782 order or subpoena from the courts in relation to banking documents, no matter where in the world the bank is based, that you will get dollar transactions, but not in other currency? In other words, but for the relationship that the bank has with its dollar banking license in New York, then you can receive those documents, but you can't receive any transactions in euro or sterling or anything else. Is that the effective?
Yeah, it's an interesting question because obviously the case isn't talking about what currency. As many of us know, the dollar-denominated wire transfers and things like that are being done typically by New York or U.S.-based banks. So they have a principal place of business in New York or in Charlotte. So you have to do the 1782 there, and then you have general jurisdiction. And then they would have to produce documents they have anywhere, because they would be possession, custody, or control, because you have general jurisdiction. They are considered to be at home. They're being asked for stuff at home. But if, in fact, there's a bank sitting somewhere in the streets of New York whose principal place of business is elsewhere, and the little tiny walk-up store they have doesn't really create any documents about New York, and the documents you want are the documents that are overseas, you would argue, if I were the other side, you'd argue this case says, no, that's not enough. The bank's relationship to the forum is incidental, and therefore you have to show that really it was a New York person in the office who created these documents. The fact that it's an email or whatever it is that happened overseas, same bank, still not enough for specific jurisdiction. So let's see, this is one court, Second Circuit, obviously a very important court because it has New York, which is obviously has the predominant financial part of the states in it. So that's an important case to watch. It could be really, really harmful for asset recovery efforts because a lot of the 1782 cases that we file are, to get at the information from places where it's not so easy to get, and getting it by the fact that they're doing business in the United States. So doing business may not be enough unless there's a principal place of business, and the kind of doing business has to be pervasive enough that you can say, well, look, this is really because of, this is the kind of stuff that's run out of the US office. If it's incidental, this is now going to shut down that kind of information. So unfortunately, 1782 took a little bit of a, for our purposes, took a little bit of a whack from the Second Circuit in that case. That's the Del Valle Ruiz case. Third case, and this is the oldest one of this group, 53 days old. So you only get new stuff when you come to offshore. Look at the old stuff. 53 days ago, in the Abdul Latif Jamit transportation case, the Sixth Circuit, so this is September 19th of this year, held that 1782 applies where the foreign case, remember the A versus B I talked about, where the A versus B is a private arbitration. So this is controversial because now there's a split. The Second Circuit, New York, New Hampshire, Connecticut, has said it does not apply. 1782 does not apply where the foreign proceeding is a private arbitration. And the statutory construction fight was over the phrase, 1782 says you can get the information for use in a proceeding in a foreign or international tribunal. And the Second Circuit said that means court or arbitration that is state-sponsored. And so did another court, another Circuit Court of Appeals. The Sixth Circuit, which would be Michigan, Ohio, Kentucky, and Tennessee, has said no, that's just a misreading. The word tribunal has forever been known to include arbitrations, and there's nothing limiting in the statute, therefore private arbitrations apply. So we have a circuit split. We don't know yet whether or not that case, there's going to be a petition for certiorari to the U.S. Supreme Court to decide the circuit split. So stay tuned. Maybe we'll get a decision that tells us one time for all. In my world, in the 11th Circuit covering Florida, they issued an opinion in a case that my firm was involved in saying 1782 applies in private arbitrations, but it was sort of a secondary ruling, and somebody must have complained because then they withdrew that part of the opinion. So we went from a win plus really great precedent to just a win, and then we lost the precedent. So stay tuned on that. Again, there were a lot of reasons given why 1782 shouldn't apply in a private arbitration, but all of those were rejected by the court in favor of the notion that the trial judge in the first instance can hear all of the gripes, all of the complaints, can hear all of the countervailing reasons, and can enter a protective order or some kind of order that limits whatever harm is being claimed by the person who's refusing to give the information. I've got two other cases, and I'm going to turn it over to Polly. Two other cases, not on 1782. Well, actually, one is a 1782, but GDPR and the United States. So you will all be shocked, as much as you all have talked about GDPR, and as how many conferences that I have gone to where GDPR has been talked about both before it was enacted, after it was enacted. We have two published cases in the US about GDPR's effect on discovery in the United States. So I have had in my practice serving a subpoena on a foreign entity that has an office in the United States, serving a subpoena on them, and them saying, oh, we'd love to give the information, but we can't because we're barred. We can't give you that information because GDPR says that we cannot. So we've got two cases on this. One is called Finjan, F-I-N-J-A-N. And by the way, find me afterwards if you need the sites for these. This is a Northern District of California case. It's a patent infringement case. And the plaintiff was asking for the emails of a UK citizen who first worked from their authorized distributor, the plaintiff's authorized distributor, and then went to work for another company doing a similar thing. And as you can imagine, the plaintiff said, hey, the man walked out with all of the intellectual knowledge, and he started another company, and he's basically stealing everything that we do, and he's using our technology, and he's violating our patent by doing so. The Northern District of California District Court rebuffed all arguments that the emails could not be produced under GDPR, all of them. So let's back up a little second here so you understand why that's not so crazy. The U.S. Supreme Court, a long time ago, in the Rogers case, held, in the Rogers case was a Swiss banking statute. It was a Swiss blocking statute that blocked production of information about Swiss banks. And the U.S. Supreme Court said, yeah, no, you got to produce all the information. I don't care about the fact that you might get in trouble with the Swiss banking authorities, et cetera, et cetera. That was followed on by another case in 1984 called Aerospatiale, which was the French blocking statute. So in the French blocking statute, the U.S. Supreme Court also said, well, no, you still have to produce the information. It's still covered by U.S. discovery. The interesting thing about in that particular case was they cut a little bit of slack, because what had happened is that the trial court had basically struck the pleadings of the defendant for failing to produce the discovery. And the U.S. Supreme Court said that was a little harsh. Yes, they still have to produce the information. They're bound by it. I don't care about the French blocking statute they have to produce, but I'm not going to dismiss all of their defenses and enter a default. You can have adverse inferences. You could do something less than a full dismissal. That was the notion in that particular case. But it stands for the proposition that creates sort of a four-part test about how the U.S. courts will deal with non-U.S. blocking statutes. So going back to this California court was applying these views. How important are the documents? I mean, are the documents tangential to the case, or are they really central? In this particular case, the California court said, look, this is really important. He's the guy who probably created the patent infringement by moving to another company and doing the technology. How specific is the request? They said it's very specific. They want a set of emails only about this technology, only about this particular patent. Was it the kind of information that was originally in the United States and brought overseas? No, this guy was a UK citizen, so that went the other way. Is there another way of getting the information? Is there alternative means? They said, no, it's either the emails or the emails. And then would noncompliance undermine important US interests? Note that there's a 5-pronged test here, and not a single one of them says anything about comity, be nice to your neighbors, don't put people in legal jeopardy, none of that. All about the US interests. In this particular case, the court held that the important US interest was patent enforcement. Infringement of patents they considered to be important US interests, because after all, patents are in the US Constitution as one of the enumerated things that Congress can write on and that federal courts can enforce. Well, you know what else is in the US Constitution? Bankruptcy. Just saying. So, in this particular case, in this Fijan case, the particular defendant was ordered to provide all of the email traffic of the UK citizen. Now, the one interesting part of it, and maybe there's a fight to be had, is that the defendant is actually an American company. So it's an American company with a UK citizen employee. So maybe there's a distinction, and that was actually discussed in the case. Whoever was defending it did not do a particularly good job of showing how harshly they might get treated by the EU for violating the GDPR. They just didn't seem to put up much of a fight about the parade of horribles that might happen if they violate it. Now, lest you think that everything goes, like typical in the United States, we have a case that could stand for anything. So we got another case that goes exactly the opposite way. Well, I shouldn't say opposite way. This is called Hansen Vest, and this is from December of 2018. Again, a GDPR case. This, interestingly, is a 1782 case. Remember the statute we were just talking about. So the applicant here filed the 1782 and asked for a bunch of information from a entity that was resident or could be found in the United States. And the defense by the witness was, Providing the information would be, quote, burdensome because it would require us, A, to bring documents and information that are located outside the United States and bring it to the United States, and 2, we would violate GDPR. The particular judge in this case, so this is a trial judge, Southern District of New York, said, I'm going to order you to produce all of the documents from all of your U.S. custodians. So you've got a U.S. entity that has U.S. custodians and non-U.S. custodians, maybe the people who have the information. So he first said, as to the folks that are in, so the employees and custodians in the United States, you have to produce everything. With respect to the non-U.S. custodians, this court said, I'm going to order you to produce the information provided that the applicant, the one requesting the information, pay all of the costs of production, so bringing the documents over, imaging the hard drive, assume all of the costs of complying with GDPR, and indemnify the witness from any violations of GDPR. Now, I don't know of any lawyer who's ever signed on a client onto indemnity. I very much doubt that they got any of that, because who would sign off on that? It's unlimited, unknown liability on behalf to get documents from a witness. So I don't know enough about the legal realism of the case to figure out whether the judge was sticking it to the applicant by putting the indemnity in, or the judge actually thought that was a viable alternative. But in any event, those are the new and dear fronts, GDPR in the United States, 2 cases published in the discovery world of GDPR, and the new 1782 cases.
Greg, before we're moving forward, sorry, Polly, just one question. Has 1782 ever been used, or is it regularly being used as a defense tool for foreign defendants?
Sure. I mean, 1782 outside the asset recovery world is just there's an A versus B lawsuit pending somewhere. Sometimes it's A who comes to the United States looking for a witness. Sometimes it's B. If you're in the asset recovery world, we tend to be the ones filing the applications because the judgment debtor, the bankrupt, or whatever else it is usually not forthcoming with the information about where the money went. So we're chasing the money. But in a regular A versus B lawsuit, B may have a wonderful defense, and their best witness for their defense left the company and moved to the United States. They got to bring them in for deposition. They got to do anything. 1782 outside the asset recovery world, for your litigation partners and your law firms, whatever, it's crazy some of the stuff that has been ordered. Blood samples, handwriting samples, fingerprints. I mean, it's basically has 2 aims. 1782 has 2 aims. One, to provide an efficient way to have U.S. persons give information, and number 2 is to try and encourage the rest of the world to be nice when we request the information from your courts. The first one has probably worked out fine. Second one, not so much.
Maybe another question. In a corporate structure where you have a defendant, say in Switzerland or somewhere else, and you have a subsidiary in the United States, and the subsidiary might not have the documents, but might have access to, let's say, a main server that's located somewhere else, can the U.S. court force the U.S. subsidiary to produce those documents?
The question under U.S. law is generally, the 3 words is possession, custody, or control. That's in our Rule 45, which is our subpoena. So possession is easy, what you have, right? Custody is you're holding it for another person. Control is the one where the big fights are. So in the Second Circuit, control means the legal or practical ability to obtain. In other places, in the Third Circuit, if you go across the river and you're in New Jersey, in the Third Circuit, it's the legal ability to obtain. So particularly if the parent is U.S. and the subsidiary is foreign, usually the parent can order the subsidiary to cough up the documents, and so you get it that way. The reverse is a lot harder, where the subsidiary has no ability to tell the parent, can you give me the files on the Swiss bank account? It's just not going to happen. So it's the issue of control. But there's fights. There's fights. You then say, well, that's interesting, because where's your main server? Oh, it's in South Dakota. Oh, great. Now I'm going to go to South Dakota. That's in the United States. Or if it's in Ireland, it's a different story. There's a lot of different ways to try and skin the cat. But that subsidiary-parent relationship in and of itself is insufficient for control of each other's documents. typically.
And do you observe anything in the way the various courts are addressing questions on 1782, any kind of universal trend because of the growing numbers of them, not just by domestic litigants who are looking to litigate overseas, but also by us foreigners coming over to try and make extensive use of 1782, not just through the correspondent banking relationships in New York, but otherwise?
When I started practicing in 1991, and I filed my first 1782 in 1992, and when I filed it, the judge looked at me like I had three heads. He had never seen anything like that. What is that? And there's still many, many courts. We filed one in Wyoming. They have never seen one of those before in their whole lives. The fact that they're now becoming more and more prevalent because the world is getting smaller, conferences like that where people are talking about it, there's a little bit of a backlash. Particularly the Southern District of New York is putting some sort of speed governors on 1782. So it used to be you filed a 1782 ex parte, meaning you didn't have to give notice to the other litigants in the foreign country. And now a lot of the judges are pushing back and saying, well, look, you have to show some special cause why you can't tell your adversary in your foreign country that you filed this 1782. So they can get out in front of it and they could tell me all the reasons why you shouldn't get it. For us in the asset recovery world, that's sometimes tough because a lot of times the person we're trying to get information about is a real dirtbag, and the less information, you just don't want them to have the information. You can't find them. You couldn't send them a notice if you want to. You know, they're long gone. They're on a boat somewhere. Who knows? So you can't practically give them notice. And secondarily, you really don't want to give them notice because if they say, oh, these people are sniffing around this particular section, let me move that money the 17th time. So it's a bad trend that I think is a backlash to the number of them that are being filed. That's at least what I see.
We call that pleading the dirtbag exception.
Yes.
It's very, very similar to what we do here in the UK. Geez, guys, that's the best I can do. Sorry. Anyway, turning then to the UK and following on from that, because we don't have a 1782. Boy, we wish we had one. We have to tie ourselves in knots. And I think one of the most interesting comparisons that you can have between asset tracing in the US and asset tracing in the UK is comparing your 1782 with our slightly tepid Norwich Pharmacol order. So the main distinction between a 1782 subpoena and a Norwich Pharmacol order from the English courts is that a 1782 is available for information that's in the United States for litigation anywhere else in the world, and I understand where you're crossing jurisdictions within the United States as well. So the 1782 application will apply as well to a litigant in Illinois who wants information from Indiana. Are those the same courts? I don't know.
You don't actually need to do a 1782.
Okay, you could just do a straight subpoena.
You could do a straight subpoena, correct.
Compare that with what we have under our sort of discretionary power in the English courts, which says that if you are a litigant, the information has to be in the UK, and so do you, and so does the defendant, and so does the person who is, sorry, not so does the defendant, but you do, and so does the information that you're seeking to obtain, and so does your litigation. That's the most critical part about it. So trying to get information through a Norwich Pharmacol order is sometimes a lot more tricky, made more so from, I do have slides. And I have to apologize because my case is not from 15 minutes ago, it's from last year. Anyway, I thought what I would do in following on from your presentation is to look at two critical problems that we have in asset tracing through the UK courts and for the UK courts. So one of the issues we have is finding a mechanism for obtaining information. Finding a way to use the orders that we have available to us in the English courts or in foreign courts in order to use that material for our proceedings here in the UK. And then a second problem, and this is something that the courts have looked at recently, is figuring out how to take action against the owner of a company who has stripped all the assets out of that company and got away scot-free. What do you do if you're a creditor against the company? We had formerly been able to bring an action in unlawful means conspiracy or inducement to breach the contract, but there's been a couple of cases developed over the last 2 years that have made things slightly more difficult for anyone seeking to recover against the wrongdoers. So let's take a look first about obtaining evidence. If I want to obtain information through a Norwich Pharmacol order or some other mechanism in the English courts, this is what I have available to me. The first of those is a Lichter and Rubin order. This is essentially an order from the courts requiring the respondent or the defendant to give information about assets which are or may be the subject of a freezing order. This can be quite powerful, but getting yourself into the contortions that will allow you to come within the ambit of what a Lichter and Rubin order will, when it will be permitted, is a little bit torturous. We have two rules for pre-action disclosure, either against the defendant or against a third party. Those are 3116 and 3117. But the most common order that is and application that's made to the English courts is for a Norwich Pharmacol order. And then again, as I said, Norwich Pharmacol orders, unlike 1782, not available where the proceedings are outside the country and not available where the materials are outside the country. I think the English courts, unlike the American courts, find themselves less willing to extend their jurisdiction over the rest of the world, whereas the Americans may be quite happy to do that, either under sort of dismissal of French blocking statutes or GDPR or any of those other things that the European lawyers have to work with. There is a fifth way, and that's through a letter of request to whatever court happens to be holding seat over the jurisdiction of the documents and the materials. And that's a request through the Hague Convention. So if we take a quick look at the Norwich Pharmacol order, and it is, again, in comparison with the 1782, a lot more difficult and becoming increasingly so. And while the U.S. courts have been being a little bit more resistant to 1782 applications, Norwich Pharmacol orders are becoming slightly more difficult to get from the English courts. As with 1782, it used to be done on an ex parte basis. As with 1782, we used to be able to get them almost as of right by simply showing that there was a good arguable case and that the respondent was mixed up in the wrongdoing and that the order was necessary in order to permit the applicant to bring their action. There's been a series of cases from the English courts that have reduced and restricted the situations in which Norwich Pharmacol orders will be granted for the purposes of asset tracing. There are now 5 conditions that need to be met. There has to be a good arguable case. There has to be no other CPR provision that could apply, so 3116, 3117 have to be ruled out. We have to show that the respondent is likely to have the documents. All of these things are usually more or less straightforward. Then we get to a thorny question about being mixed up in the wrongdoing. How close do you have to be connected to be mixed up? You have to not just have observed the wrongdoing. You can't be a mere witness to it. You have to actually somehow have involvement within the misconduct that's being alleged in the underlying case. And then still you have to show that the order is in the interest of justice. Having met all of those conditions, you then have judicial discretion. So you might, and I have experienced this, it's not pleasant, sat through a 2-hour judgment from the judge who explains to you in great detail how carefully and cogently you have met all of the conditions and argued everything very, very successfully, but he just don't feel like it. So he's exercising his discretion not to give you the order. And that's a painful one. However, there's something even more painful than that, and this is the case of Ramela that came through the courts last year. Incidentally, are there any English lawyers in the room? And has anyone seen the Ramela case and its applicability to Norwich Pharmacol orders? No? No one's fallen down on this one yet? Just me then. Ramela was a case, and I won't go through the details of it because it's the usual torturous asset tracing theme where Company A, Company B, chasing one another all over the world, allegations, abuse being hurled on both sides. The critical point about it is, it's on the slides if you want it, but the critical point is what Ramela does for us. There was an application for a Norwich Pharmacol order, and the question that came out of this was whether or not you could have a Norwich Pharmacol order where the proceedings that were being contemplated were not going to be in England and Wales. And the judge decided that no, if the proceedings are going to be in England and Wales, fine, you can have your Nordpharmacal orders provided that the documents are here. But if your proceedings are contemplated elsewhere, you can't come to London, use our handy little mechanism of an MPO, and then scoot off back to Cyprus or Malta or the BVI or wherever else you happen to be domiciled. So there is a mechanism for obtaining foreign evidence for use in foreign proceedings, and that mechanism is the Hague Convention and the 1975 Act. And it created these new words, which we are calling an exclusive jurisdiction. The 1975 Act, we're told now in Ramela, is an exclusive jurisdiction. If you want evidence from somewhere else, then you don't want to use it in your domestic proceedings, then you have to use the Hague Convention. It's not that terrible of a situation to be in, and it's helpful to have it clarified. At least we know now that we have to do a letter of request through the courts. It's imperfect because, of course, not only does your own domestic court have to recognize your necessity for getting the order, we also need to make sure that the foreign court is going to recognize your necessity and enforce the order that you're seeking. But that is the situation we find ourselves in now. Ramela has been tested, tried, and applied several times since last summer. And no one yet has seen fit to do anything to overturn it. The only sort of light on the horizon is a case called Schleimun. And the number of times I sat in court last summer listening to someone say the Schleimun exception, I can't really count them all. Effectively, the Schleimun exception seeks to create a little window of opportunity. Because Nordpharmacal orders are most often sought in advance of litigation being brought, in other words, it's pre-action, you might not know where you're going to bring your claim. So you might be thinking about bringing it in London, it might be Cyprus, it might be Hong Kong for all we know. You don't know where it's going to be. So the Schleimun exception says that if you are seeking information that you need from the courts, who to sue, what to sue, how much, whatever it might be, if you require that evidence, and the only way you can get it is from an order from the English courts, provided that you don't know where you're going to sue, the Schleimun exception applies. However, if you at any point, at any time, decided that you were going to litigate in London, but the material was overseas, the Schleimun exception cannot apply to you. The dirtbag exception might. We don't know. I have given some detail in the slides about the 1975 Act, but the English court's application of the Hague Convention is by and large fairly conciliatory, particularly when the request comes from the United States, a little less so when the request comes from other jurisdictions. We've done 4 Hague Convention applications this year. They have all been waved through within 21 days. And that is actually a fairly useful mechanism for anyone who's seeking to obtain information in London for use in their domestic proceedings elsewhere. It's true that GDPR is a little bit more of a hurdle, and there has, in every case, the question has been raised as to whether or not GDPR entitles the respondent to refuse to comply with the Hague Convention request.
Polly, what's your experience with how fast a U.S. court can get their letter rogatory, their letter request out? Because many of our judges, if I walked in and I asked, I filed an application for a letter rogatory, the same people who didn't understand what a 1782 didn't understand what a letter rogatory is either.
Well, the ones that we've done this year have been astonishingly fast, almost mind-blowingly fast for those of us who are used to waiting through the long vacation to get a judge to read and decide an application on the papers. I will say that was a very long-running case, and it was a very engaged judge in the Southern District who was dealing with it. It was just almost astonishing when the American lawyers, we'd have these conference calls and we'd say, we'll need you to make this, get this letter of request to the English courts. So when can we expect to receive that? May, June? And they'd go Tuesday. And that was a confidence that I found kind of breathtaking and also envious. So enviable, sorry. So, looking on to our next topic of things that bother me and keep me awake at night, it's this one. This one just doesn't seem fair, and it seems wrong-headed. This is where an ultimate beneficial owner of a company enters into a contract with, say, for argument's sake, my client. That ultimate beneficial owner of the company then strips all the assets out of the company, breaches the contract, and runs off with the funds. I then have the opportunity to bring an action in breach of contract, but I can't bring that action against a company that doesn't have any assets. It's useless. So this is a question about piercing the corporate veil, but it's also a question about bringing a tortious claim against the wrongdoers. So the ordinary position is that you can bring an action against someone who strips the assets out of a company, except and until, and I'm just skipping on a slide, we get to a case also from last summer. I did have a really bad summer last year. A case called Merex. Now, in Merex, the decision was that something called reflective loss was going to stymie all attempts by the individual defrauded shareholders and creditors to try and recover funds from the defendant who had stripped the assets out of the company. And it took me a long time to get my head around reflective loss, but the essential position is this. If you permit one creditor to bring an action against the ultimate wrongdoer for inducement to breach the contract, unlawful means conspiracy, however you're going to plead that tortious claim, the court says in Merex that would be unfair. That is a case or a claim that should be brought by the company itself. Now, hang on, the sensible among us think. So what you're saying is that if I control a company and then I use that company to defraud some very unsuspecting shareholders, then only that company, which, let me remind you, I control, can ever bring the claim against me. Happy days, quids in, we're all done. But that's the position now. So the case of Merex has left us with a slightly unsatisfactory position where there is an automatic defense to any claim for inducement to breach the contract or unlawful means conspiracy where a company has been used as the mechanism of the fraud. I really don't have anything to add to that except that it's unsatisfactory and unpleasant. Although there was an attempt made in this case, Palmer Birch. Palmer Birch is awkward because in that case, the judge said, no, there was a fraud. You can't use a company to defraud unsuspecting shareholders. That seems completely wrong. I say that, yes, this is fine. Reflective loss doesn't apply. So that case was heard. In the intervening period between Merex going from the Court of Appeal to the Supreme Court, where it rests today, the case has been heard already, but Supreme Court judgment hasn't been handed down. So Palmer Birch doesn't apply or distinguish Merex, it simply ignores it, which I would like to do as well. Unhelpfully, I am not the judge in the High Court, so that leaves us with this position on reflective loss, which is we just don't know. And I don't think I've ever left such an unsatisfactory presentation, but there it is. That's the situation in the English courts.
Thank you very much, Polly. It's really interesting. Could you pop up my presentation, please? And since it seems we're quite out of time, because on the other side they're already clapping, and I've seen a couple of people, at least intermittently, closing their eyes already, I really don't want to steal any minute of your coffee break. So I'm going to rush through my slides. Usually from a Liechtenstein perspective, the typical situation is that nice people like Polly or Greg or their clients are approaching us in Liechtenstein and telling us, well, we have a case going on like for a couple of years already. We're litigating. We've survived, summary judgment or motion to dismiss. We're going or we were at the discovery stage already, and we just found out, well, all the assets that we were fighting about have been transferred to Liechtenstein. And they're asking us, what can we do about this? The main interest of the client or their respective counsel is to first secure the assets, of course, get a freezing order, and afterwards, is it possible to enforce the foreign judgment that they're expecting or that they already have, if we're talking about a follow-on proceeding, in Liechtenstein into those assets that have been transferred to a structure, a Liechtenstein structure of the foreign defendant, which is then usually also the beneficial owner of such a structure. And oftentimes, at least if they're not doing it really smart, has also some sort at least of control over these Liechtenstein structures. So freezing of assets, enforcement of foreign judgment. Then the question is it necessary to run parallel proceedings in Liechtenstein? Can we stay, and if yes, can we stay such parallel proceedings? And then, is there any means that the Liechtenstein structure as such is liable for the claims against the beneficial owner? Meaning, in Liechtenstein terms, is there either any direct claim against the Liechtenstein structure, or is there a reverse piercing of the corporate veil, meaning that the corporate structure is liable for any wrongdoing that the beneficial owner of the structure committed? So freezing of assets, you really have two possibilities. First, you can apply for a preliminary injunction before Liechtenstein civil courts. It's pretty much straightforward because the requirements are that you need to show your claim, of course, against the beneficial owner of the structure, which then could be enforced into the structure itself. This showing has to be made by preponderance of the evidence, so it's rather easy to do this if you're already having a claim outside of our jurisdiction, and you might already have some more information from the discovery phase, and there needs some risk that the enforcement of the claim is thwarted by the defendant, which is the beneficial owner. So this second prong might cause some troubles because if you haven't just caught the beneficial owner, the defendant in the foreign proceeding red-handed, and in the face of discovery they transferred all the assets, it might be difficult to show some subjective risk on the side of the beneficial owner to further funnel the assets out of Liechtenstein. What other problems you might face in Liechtenstein is that the Liechtenstein structure, which is oftentimes not a single corporation or trust, but often a rather complex group of companies and trusts, because Liechtenstein trustees tend to be very thorough and not only sell one trust or foundation, but a couple of them if they get the possibility. Then you have the risk that those structures might join the freezing or the injunction proceeding, doubling or tripling your cost risks in such proceedings. Then oftentimes, if you have a good case for criminal conduct, for fraud, for money laundering, it might even be easier to go straight to the prosecutor, launch criminal charges, file a criminal action with the prosecutor, so that this one can start the proceedings, the criminal investigations, and apply with the Liechtenstein court for a seizure of the assets to secure a later forfeiture of these assets of the Liechtenstein structure. And there you don't have problems that there's a distinction between the beneficial owner and the structure, because criminal law sort of looks through and takes an economic view of things. Those kind of criminal proceedings and seizure orders can or are often also caused or initiated by letter-rogatory proceedings in support of foreign criminal investigations. And what is more, such foreign criminal investigations, and if there are interrogatories requesting a seizure of the assets, oftentimes also lead to own Liechtenstein criminal investigations on money laundering, because prosecution and courts increasingly tend to be very sensitive about money laundering aspects, especially because there has been huge international political pressure onto Liechtenstein, but not only, but there's Switzerland or Austria as well, to name just a few. So there are a couple of downsides if you go down the criminal investigation route, because you're not, so to say, the lord of the proceedings anymore, but the prosecution then decides whether it is necessary, if the case is strong enough for one, and then whether it is necessary to have a seizure of the assets. So you give away the control of your case to the Liechtenstein prosecutor. The requirements are pretty similar than in the civil court. You need to have probable cause for the criminal act, which is somewhat lower than that you have to show the claim with preponderance of evidence, and you need to show the risk that the forfeiture might be thwarted through possible acts of the defendant, the beneficial owner, or the trustees of the structure. This might seem or sound very similar to the prong in the civil court proceedings, but it actually isn't, because the courts in criminal matters tend to just grant you the seizure proceedings or the seizure order, especially at early stages of the criminal investigations, because courts then argue that the prosecution at such stages oftentimes don't have the information to really establish those two prongs with a high degree of certainty. What is to mention as well, and that might be interesting for all those who are working on the CumEx cases, Liechtenstein courts or the money laundering provision and the forfeiture provisions in Liechtenstein law are now also applicable on tax fraud schemes, which means that all monies that have been saved or have or are derivative from such foreign tax fraud schemes may be seized and then forfeited in Liechtenstein criminal proceedings. Bad news on the enforcement side, unfortunately. Foreign judgments, except for Austria and Switzerland, are simply not enforceable in Liechtenstein. You need to go through a further special debt collection procedure, but this only means that afterwards you can turn the foreign judgment into a Liechtenstein judgment, but the defendant has the possibility to initiate by way of his or her own lawsuit to initiate special proceedings in order to nullify the foreign judgment or the Liechtenstein judgment that is based on the foreign judgment. So basically you have to redo the whole case in Liechtenstein, and there's no way you can enforce a foreign judgment in Liechtenstein, unfortunately. Then oftentimes people ask us whether it's necessary to really then run parallel proceedings in Liechtenstein when there's already a prior proceeding going on or has already been concluded in the foreign jurisdiction. And in terms of maintaining the freezing order in civil courts, our answer at the moment at least is yes, it is necessary, because foreign judgments are not enforced in Liechtenstein. They also are not sufficient to maintain freezing orders in the civil court. Then the next question would be, can I at least stay a Liechtenstein proceeding pending the outcome of a foreign proceeding? Our rather conservative answer at the moment is, I would doubt so. it's usually the courts at the moment tend to not interrupt or not stay Liechtenstein proceedings pending the outcome of foreign proceedings. Those 2 points, though, are pretty disputed at the moment. There's clear literature from Austria on the first point. So this question it's not, there's no case law from the Liechtenstein Supreme Court or the Constitutional Court, but there is a clear tendency on the second issue. This is, I would say there's a tendency at the moment in lower courts, in the instance courts, district courts, and courts of appeal, but there's simply no answer from the Supreme Court at the moment. So another thing that Polly already mentioned is piercing the corporate wheel, and I've used this term reverse piercing the corporate wheel, where a Liechtenstein structure is liable for the wrongdoing of the foreign defendant and beneficial owner. There you simply have to show a misuse of the Liechtenstein structure, which is not too hard actually if you have the information, if you get the information from a 1782 order or production proceedings. But if you're left, if you have, for instance, a sole domestic case in Liechtenstein where you don't have these wonderful measures of gathering information, you're simply left without nothing. And then your only route is first initiating criminal proceedings and then go for this. But otherwise, you simply don't have the information of an internal misuse or a misuse between the beneficial owner and his or her structure. So there, we simply, on the basis of evidence and information, we have difficulties that we most of the time simply cannot overcome without the help of foreign colleagues or without the help of the prosecution. But then there's possibilities to invoke or assert separate direct claims against the structure, which are based usually on money laundering, damages claims based on collusion, creditor protection claims, unjust enrichment claims. So we have lots of causes of actions against Liechtenstein structures, but you have to be quick about those because limitation periods, whether you have foreign proceedings ongoing or not, they're simply running under Liechtenstein law. Limitation periods, when you're talking about creditor protection claims, they can be as short as 1 year. Damages claims are time-bound within 3 years of knowledge of the wrongdoing and the damages. Some limitation periods are a little bit longer, like the unjust enrichment claims. But you have to get going. As soon as you know there have been assets transferred to Liechtenstein, you basically should call us. And I think that's even it. I hope I haven't taken too much of your time, of your break time, and thank you very much for your attention.